Like everyone is ready. We now have the case of State versus Flynn, and the state may go first. Mr. Sloven.
Thank you, Madam Chief Justice, and may it please the court, counsel. Good afternoon. It's a privilege to be here. Implied consent is neither mandatory nor exclusive. This was made clear in Demarais, more recently made even more clear in Laub. The legislature spoke on this topic in 321J.18 that nothing in Chapter 321J should be construed to limit the admissibility of any competent evidence of a defendant's intoxication, as proven by a chemical test result. That includes any provision that lays out this available route that an officer can choose to take to invoke implied consent. The district court and the Appellee's brief argue that the state has made up this term invoking implied consent, that it doesn't appear anywhere in the authority or in the case law, but it does. It appears in Demarais, where the court noted that the officers didn't invoke implied consent, and therefore implied consent was not the framework under which the implied consent requirements didn't apply, and failure to follow them didn't mean that the evidence was inadmissible. Implied consent wasn't invoked, and therefore 321J6 and 321J8 didn't apply.
In law, we wrote that 321J is the statutory scheme to implement the consent exception to the Fourth Amendment. So what do you make of that language? And I understand your briefing was done before Laub and McMickle were decided, so I wanted to give you an opportunity to respond to that.
From Justice May from earlier today, I think that might be loose language. Now, I've never understood implied consent to be valid consent in the voluntary, knowing, and willing flavor of it. That it's kind of a legal fiction that we have that when you agree to when you get a driver's license, we impute your consent, even though we don't require evidence that you were told about this when you get the driver's license or that you understood it.
21J structure, the officer always has to obtain actual consent before administering a chemical test. Isn't that correct?
Yes, but it's a different kind of consent. And what I mean by that is they are given a statutory right to withdraw that imputed consent within the implied consent framework. So once implied consent has been invoked, now they have a right to withdraw that consent and to refuse to submit. But invoking that right, exercising that right carries evidentiary consequences, revocation consequences, fines, all created by the statute. The decision whether to exercise that right to withdraw that implied consent, that must be voluntary. It has always needed to be voluntary. But we're not saying that implied consent from the get-go at the moment of getting the license was a voluntary, right? So what I'm trying to get at here is that they are different exceptions to the warrant requirement here.
At the end of the day, whether it's consent under Fourth Amendment exception or consent under 321J, the motorist actually has to give consent. And in law, we said that this statute was meant to provide extra protection as a way, kind of a statutory scheme to implement the consent exception. Doesn't mean it's required, but that's just how, at least that's what we wrote.
I think that single sentence is dicta with regards to what else is in Laub. It's not really called for by the holding. And I think that it doesn't really make sense with our other cases like Demarais and Oakley.
Let me look at it this way, Mr. Sloven. The statute 321J8 says, a person who has been requested to submit to a chemical test shall be advised, blah, blah, blah. Why wasn't Flynn here a person who was requested to submit?
He was offered a chemical test. The officer asked him if he would take a chemical test, but this isn't a request to submit as the term is used by the implied consent statutes. 321J starts by saying, here's the situations under which consent is deemed or implied or imputed. The withdrawal of a chemical sample pursuant to that deemed or implied or imputed consent shall be at the request of the officer.
Met and he said yes.
No, he was not within the term of art as the statute employs it.
Officer said, I am requesting you submit to this chemical test.
Gets to an interesting question of when precisely do you say something is an invocation of implied consent and when isn't it, right? And I don't think it's the use of the words request to submit. You know, it's a legal term of art here. So I think that in Wallen, this court had to consider whether to distinguish boner or whether to apply it. And because it cites, maybe quotes language from Boner that says, actual consent obviates the need to comply with implied consent. Well, then how do you know if and the question in Wallen is, well, are we in actual consent territory or are we in implied consent territory? This already is a recognition that implied consent is a route that officers may take, and actual consent that precedes and obviates it is an alternative route.
Is this, and it should be fairly simple. If you're saying the statutory trigger is invocation of 321J, when does the officer invoke 321J?
Would say is that you're looking for two things. When you have both of these things, you definitely have an invocation of implied consent. One is the presentation of a written request, and maybe an oral request would also suffice in certain circumstances if it's made with the same formality, if it's like explained, here's the basis for the request. And the second would be the mention of consequences of refusal, because that really is the essence, the beating heart of implied consent. I mean, that's what this court recognized in Laub, is that the reason that we have implied consent is to, in practice, it ends up limiting the circumstances under which officers may assert and demand a right to conduct a warrantless breath test or blood test.
From defective reading of rights. So let's assume this officer didn't understand 321J very well, and he thought he was invoking 321J, but he just didn't give the advisories. Maybe he didn't give them in written form, and he gave them orally. How do we make that determination?
So that's going to be a case-by-case determination that comes down to, and I think that presenting consequences of refusal, which you are not authorized, are not statutorily authorized and cannot be triggered in the absence of an invocation of implied consent. Once you are talking about, you could also.
I think most people understand that implied consent is out there, and when that request comes, I don't know that people are really listening for the magic words that would trigger this statute versus what you're talking about. Isn't this going to create all kinds of problems with this sort of slicing and dicing of the way that questions are asked?
I don't think so. And the reason is because officers have been operating with implied consent for a long time. We have the written advisories and we have a lot of case law on it. And officers are understandably wary of bungling implied consent, deviating off script. I mean, that itself has created problems where detainees or arrestees will say, I don't understand, and the officers know the only thing they can do is reread the advisory, even if that didn't clear anything up for them. I think that the way that this is being implemented is, Laub said it was perfectly permissible for officers to disregard implied consent entirely and just get a warrant. Well, this just adds a new step before that, which is before we get a warrant, maybe we don't have to. Maybe he'll just waive the privacy interest just totally voluntarily without any mention of administrative license revocation, fine, evidentiary consequences from refusal, without any mention of that, anything that would turn this from are you waiving a privacy right, a constitutional right, into are you retracting your statutorily imputed implied consent? That's just, it just makes sense to see if you need to get a warrant or not. And that's what the officer describes as the policy here, that
matter, given what we said in Laub, that officers can use search warrants, and given what some jurisdictions or what some counties are doing and just going straight to search warrant, especially now that you get electronic search warrants, what's the practical problem that's created by interpreting the statute in the way that it says, which is when an officer requests a chemical test, you have to give these advisories. So they can make a decision. I'm either going to give the advisories, do informed consent, or I'm going to get a search warrant. It doesn't seem to me to be such a hindrance to prosecution of OWI cases.
So it isn't a hindrance in cases where the officers just get a search warrant. It is a hindrance in cases where officers ask for consent but it doesn't fit neatly into this creates, if you view implied consent as mandatory and exclusive way to ask for consent, suddenly you have a problem when officers are like, well, I'm running up against the 2-hour deadline from when they refused the PBT or when they were arrested. I don't know if my request is going to be complete within the 2-hour window created in 321J6. And so now they have to decide, well, they can't ask for consent normally because if implied consent is mandatory exclusive and they're wrong, then it's invalid. But if they read 321J8, the advisory, and it turns out they're outside the 2-hour window, well, then they've given misadvice, and then they're wrong there too. Consent, the same thing goes for if they encounter some other unforeseen problem where they're like, well, a court is going to want me to have taken reasonable steps here, like a Baraki kind of situation. They're going to say, a court is going to want me to take reasonable steps here. I'm not sure what those are. And I don't have any confidence that a court that reviews this later will necessarily think that I acted reasonably no matter what I do. I'm confronted with multiple bad options here. And so this provides them an opportunity to say, maybe I can just get voluntary consent. And the best part is, if the person doesn't want to provide the sample, they can just say no.
I think maybe Justice McDermott alluded to this earlier. I mean, everybody in Iowa kind of labors under this impression that there is this implied consent procedure, and that if you say no, you are going to suffer this adverse consequence of losing your license. So isn't there some obligation to at least cure that impression? Say you can say no without the possibility of losing your license?
I don't think any of our cases that involve waiver of a consent to waive a privacy interest and permit a search or a seizure, I don't think any of those cases have adopted a requirement that the officers say, you may say no before that consent is voluntarily given. Definitely they can't say, you can't say no.
Schemes like the implied consent statutory scheme?
I'm not sure. No, I don't think so.
On this, I'm thinking of my days as a former prosecutor and then a trial judge, and I'm thinking defendants would have loved what the state is doing. More often than not, they'll do anything. Please don't take away my license. I'll pay a fine. I'll do time. Please don't take away my license. Well, implied consent's already been invoked and all that business. So there's going to be some DOT ramifications. So I'm trying to wrap my head around, why are they doing it? There's a beautifully articulated and we have a lot of jurisprudence on the 321J statutory implied consent. What's going on here?
So I think the one factor here is that the policy seems to have become, we're going to get a warrant rather than implied consent, which Loud permits. And then the evolution of that is, well, if we don't need to fill out a warrant application, then why would we? And so they can just make an ask. And if Mr. Flynn here seemed very agreeable, very cooperative, and he already took the...
Cops are looking for a shortcut.
Consent is always a shortcut to judicial process. In the Fourth Amendment context, we always permit this, that a person has a privacy interest that they could assert.
Actually, I just asked, it doesn't have this undercurrent of another statutory scheme. There's nothing similar to our implied consent as there is to like search of a home or something like that. This is a different situation. It just seems to me like they're trying to shortcut, just like when a cop asks, go straight to PBT and no fields. And if you test positive, then we'll do the fields. I mean, that's a shortcut too, and they're not allowed to do that. How is this different?
Shortcut is just one way of saying selecting the most effective tool for the job in the moment. That this turned out to be a case where the officer didn't need to threaten consequences for refusal or read a long advisory in order to, the person was just willing to provide the test.
Let me ask a question about the record. Was Mr. Flynn given an opportunity under 80420 to make a phone call upon arrival at the station?
I don't think that the officer affirmatively told him about his 80420 rights. I know that this court has said that it's simpler in implied consent context if you just make that disclosure, as part of the implied consent advisory reading. However, I don't think that it's even required.
Was there a phone there that was available? Did they take away his cell phone? Do you know?
I'm not certain, and there was no claim of an 80420 violation, so this was never explored. I will say that the one exchange that I found significant is that Mr. Flynn, the officer asks him, will you take this chemical breath test, and he says, well, I already took the PBT, and the officer says, well, that's not admissible in court, right? So the one thing that you could arguably say a person, the one real consequence of this test outside of implied consent, the evidentiary consequence, he was told about. So I can't see how he could possibly be prejudiced by any alleged statutory violation that occurred here. Thank you.
Ms. Carlson?
May it please the court. We find ourselves in a unique situation today where the state seeks to change the rules of the road in the middle of the game. The state's appeal seeks to unravel a carefully crafted balance between the preservation of public safety and the protection of individual rights.
Often attacked by defendants, that challenged. And now today, it's funny to watch this. I'm going to take off kind of what I asked Mr. Sloven. In my experience, defendants would have loved this. I can say no, you can maybe get it a different way, or I could say yes, but I'm not going to have any driving license revocation issues. What is the complaint? If it could have been done another way, you're saying do it the other way that has harsher consequences, driving.
The court has found that the protective standards, the legislature enacted this particular statute to ensure protective standards in how these specimens are requested. Because when we're making a request for a bodily specimen, it's different than if we're going to ask to search a home or a purse, because it's invading the body.
Those are all constitutionally protected areas, though, right? But let me ask you a different question. What if a defendant simply volunteered from the get-go? Cops pull him over, and cop comes up, and they start talking, and before there's any discussion of testing, the defendant were just to offer, I'd like to do chemical testing. I can tell you're concerned about my drinking. Now, that would be consent in its purest form. Would it be your position that that's not good enough?
Different because implied consent is dealing with an officer that is making the request. And the court has considered a similar issue in Carlson where the defendant actually did offer to make the request or to give the sample. And so the court in that case relied on that and used that as this distinguishing factor, that because the defendant is the one making this offer, that it was voluntary.
So let me ask you a separate question. Do you agree with Mr. Sloven that, or I presume not, that if the officer simply asks and does not bring out sort of the sticks of the implied consent, that's improper, that's not consent?
Consent. I think that implied consent is invoked when the officer makes the request. There doesn't have to be any mention of the negative consequences with the DOT for it to be considered implied consent. It's when the officer has reason to believe that the suspect was driving in violation of 321J and they make the request for the test.
Implied consent. Isn't it actual consent?
It's because it's invoking that statute and he's making the request under the statutory framework. The court has stated that 321J is essentially a statutory scheme to address this voluntary consent issue where you wouldn't need a warrant.
How do we line this up with Demaray, where we said that we read Wallen to stand for the proposition that the statutory implied consent procedure must be followed, but only when the implied consent procedures are invoked? I mean, it gets us back to this invoked question, right?
That is the problem that's caused here. When the state is saying that, there's different ways that you ask the question, how it's phrased, that's going to determine whether it's invoked. But that's going to cause a lot of confusion for trial courts to have to suss out whether it was invoked. looking at prior case law and looking at the specific language of the statute, I would argue that implied consent is invoked when a peace officer having reasonable grounds to believe that the person was operating motor vehicle in violation of 321J2 makes the request. When the officer asks for the sample, that's when we're in implied consent. And that's where these mandatory procedural provisions must be followed, because the legislature used the word shall. And so once that request is made, the officer shall inform the defendant, the officer shall make the written request.
I agree with that part of it, but there's a statutory gap under 321J6 where the officer is not even allowed to request chemical testing unless there's reasonable grounds to believe the person's operating while intoxicated and one of 7 conditions occurs. One of those is arrest. So what do you do with a request for chemical testing prior to arrest, which were the facts of Lob, if I recall correctly? And we said one of the problems in that case is that the officer wasn't even authorized under 321J to request consent. So what do we do with that gap, a pre-arrest request for chemical testing?
The officer will have other options, like in Laub, the officer could apply for a warrant and get the test that way.
Why couldn't the officer request for consent at that time? I mean, the statute clearly doesn't apply because the threshold hasn't been met.
But they had been under the suspicion of operating while intoxicated. So if you're requesting evidence that's going to be an essential element of the crime under 321J, under this entire statutory scheme, because there is that suspicion, it would be within the implied consent realm. Another issue, the state has taken the position that essentially, there's no harm here because Mr. Flynn's license has not been revoked. They allege that he voluntarily consented. But as the trial court order pointed out, this is a slippery slope for officers to begin asking for voluntary consent in concerning ways. And we've seen this already in Dubuque County, where officers have, again, under the same color of facts, have simply asked for the suspect to take a chemical test, but in situations where they don't even tell them that they're under suspicion of OWI.
A lot of defendants out there who would like that opportunity to give a test without the DOT ramifications. That it kind of, when you say slippery slope, it also, that hill goes up and down.
I don't think that defendants ever like the specter of having to lose their license. However,
For example, CDL.
but I think that's why it's important, because that is actually part of the statutory scheme, is going through what are the consequences of this going to be, and they specifically address, like you said, issues that are going to occur if you have a CDL. So that's why it's important and that's why the legislature specifically directed officers to go through those consequences so that they could make an informed and voluntary decision. So I think,
Please go ahead, finish.
just to conclude, I think that, while in the short term, defendants may want to keep their license until the time of trial, there's still the overarching concern that this isn't going to be an informed and voluntary consent without those notice.
One more question about Justice McDermott brought up Whalen and Demaray, and it seems like we would have to, if not overrule those cases, disavow some of our language in there for you to win. Is that the way you're looking at it?
Of our case are distinguishable, and specifically the issue of whether the officer's request is allowed outside of implied consent. Now, in Demaray, what happened in that case was the blood sample at issue was taken by medical personnel for diagnosis and treatment. So it was already existing. The officer didn't specifically ask for the blood to be drawn. So this is distinguished because the officer wasn't the one making the request. So I don't think that we necessarily have to overrule those cases because there is that difference when the officer is the one making the request versus getting the evidence some other way.
The officer have to get a release, though?
Officer had the defendant sign a release that waived the patient privilege. But like I said, the sample was already existing. The officer didn't ask the medical personnel, will you draw the blood for this? They had already withdrawn it and tested it for treatment purposes.
But still, the consent that was given by the defendant there was independent of the implied consent process.
Was outside implied consent, and that's allowed under 361J or 321J18, which provides that other competent evidence can be used to show that the suspect was intoxicated. But again, there's a very important distinction that it's not the officer making the request to the defendant to provide the specimen and for it to be tested.
In these time-sensitive interactions on the side of a road, that we have a clear, bright line, that it's easy to tell whether what law governs, and isn't the easy test the one you propose, that if he asks, will you take a breath test, they're now under the statute, and you got to give all the disclaimers the legislature has mandated.
It's easier for officers because when they go to do the test, they know I have to do this, it is mandatory. It makes it easier for the trial courts because they don't have to go through and distinguish what language did the officer use when he invoked implied consent. Was he demanding that the person take the test? Was he asking, do you withdraw your consent under the implied consent statute? Trial courts aren't going to have to go back and parse that language because it's mandatory. It follows the statutory scheme.
Sloven, about 80420, I'm going to ask you the same thing. Was your client afforded his 80420 rights?
I don't believe, I don't recall from the record if before the testing had occurred, he was afforded the opportunity to or told that he could call an attorney, but it was not an issue in the lower proceedings or raised in briefing. But I'm sorry, I don't know the answer to that.
The officer doesn't have to offer a phone call, does he? His 80420 is triggered when the driver asks to make a phone call or asks if they have a right to, and then you have to be accurate in your response, right? Okay.
Can I go back to the 321J18 issue? I think the state argues that this evidence is competent. It was obtained voluntarily. It wasn't obtained in violation of the Fourth Amendment. So at least the statute would indicate that the evidence should be admissible in the OWI trial. What is your response to that?
I would disagree with that because, as you stated in Laub, 321J is a comprehensive statute of how to get that voluntary consent. So in other words, if an officer is seeking consent, 321J tells them exactly how they do it. And other cases have specifically stated that this is a procedural requirement because it lays the foundation for the admissibility of this evidence in the criminal trial. So we would still need to follow the mandates of that implied consent structure.
When you talk about the implied consent to get a voluntary consent, I don't find that to be voluntary. When you say, we're going to use this against you, if you say no, you're going to get hammered harder by the DOT than if you'd say yes. And if you're over our limit, we're going to ding you for X number of days. Oh, and if you have a CDL, I mean, to call that a voluntary consent is stretching it. But I think what was actually done in this case is more akin to a true voluntary. There was none of that baggage attached to it. It was just plain, hey, will you give me a sample? Yeah, I will.
Right, but the officer never explained, what are the consequences of this? And, this is how the statute.
Is when you're going to ding him with the DOT. He had no intention of dinging him with the DOT.
That's the way that the legislature wrote the statute. And as courts have looked at this issue over and over again, they have found that this is, when they follow the implied consent procedure, that is voluntary consent.
You're going down that implied consent path, and I think most cops do this. Like I asked Sloven, I'm not sure why they're doing it. But regardless, they're doing it. And I'm trying to figure out where's the authority that says they can't? Just because it's kind of unique, and actually I might be shaking my head as a former prosecutor. I might have told my people, stop doing that. I don't know. But I'm just trying to figure out where you're getting the authority that says they can't if they're not tying it to DOT.
Maybe really respond to that. The authority is in the language of the statute specifically. It uses the word shall. If an officer is going to make that request, they shall advise them of this. If the officer is going to make the request, they shall receive written consent ahead of time. And so that's the authority that says it must be done in this way.
Anyone else? Okay, thank you. You may be seated. Mr. Sloven. And while you're walking up, I'm going to ask you my next question. What if the statute said something, and would it be simpler if the statute said, if consent is going to be requested pursuant to implied consent, you have to do this? Wouldn't that make it clearer?
Your Honor, I think it would. I think that's very clear from the context, from the content of, specifically 321J8, from the content of the warning. Giving those advisories about the revocation consequences is something that should not be done unless those revocation consequences apply. Let's say you're more than 2 hours out from PBT or arrest, 321J6(2) says a test will not be required. Well, then definitely don't read 321J8 about the revocation consequences or the evidentiary consequences of refusal, because those, it's not required, those don't apply.
Let me ask you this hypothetical, Mr. Sullivan. All right, so what if Mr. Flynn had said no? Could the officer have then just said, okay, now we'll go into the implied consent, and I'll start reading you the advisory. And then if you say no this time, then you get your license suspended.
I think that's permissible. There's no statutory
Of each other.
statutory bar against that. I also,
The cops do the double thing in every single case. What do they have to lose?
Justice Christensen pointed out that implied consent offers an array of consequences and helps incentivize the choice to take the test, producing evidence that's useful in prosecution, and has an array of regulatory consequences that are generally pro-social. So I think officers are very heavily incentivized. I mean, that's why there's not a flood of these cases. Generally, officers are incentivized to use implied consent.
I mean, because why wouldn't they use both? And if the answer is no, just jump into implied consent.
For implied consent, then you don't get any of the triggered revocation consequences from a submit to a request. Revocation consequences like triggered in 321J12. There's also consequences. We point this out in a footnote in our briefing. Consequences at sentencing. For example, Mr. Flynn is eligible for a deferred judgment because his test wasn't given in, and this is all the same stuff that would happen in Laub, because in Laub there also isn't a submission to a test under implied consent or a refusal to submit. It's withdrawn pursuant to a warrant. So the same, it kind of puts you in the same situation going forward because you don't have an implied consent choice and a test resulting from that choice that triggers a lot of these revocation, monetary, other pro-social consequences that the legislature generally likes and generally wants.
What do you mean? You gave that answer. I'm not sure which way it cuts. Are you saying that the statute is designed so that officers should give it because there are pro-social consequences that come with giving implied consent? Or there's pro-social consequences for skipping it and evading the statute?
This is an incentive that officers have to use implied consent. I'm arguing against the parade of horribles that if the state wins this case, officers will never invoke implied consent again.
Don't we do it? if you
Officers more tools in the toolbox so that they can use the tool that fits the job.
police officers to do it because it's pro-social. The text of the statute says a person who has been requested to submit to a chemical test shall be advised by a peace officer of the following. So why work so hard to avoid a statute that, as I understand your argument, you think is good?
It's good that officers have a choice whether to use it, and I think that in most instances, they probably should. Now, I recognize, giving them more tools in the toolbox, more options, this is a case where a lighter touch was sufficient. Mr. Flynn did not need to hear that.
Like for the district court, if it wasn't quite so clear, whether or not, so when the officer asks for consent, he claims that he got actual consent, and then you get to the defendant then files his motion and says, no, I didn't give actual consent. You rely on Wallen, where we said that the person who's arguing for actual consent has to be clearly proven that consent was voluntary, freely, and intelligently given with a full realization and comprehension of its meaning. So what is the district court going to be looking at to decide if that's what you were given, or really you were invoking 321J?
Courts have a very familiar set of tools, a totality of circumstances analysis to assess voluntariness, whether the person's will was overborne, whether the decision was willingly and knowingly and intelligently made. This is an inquiry the courts are familiar with. This is the underlying voluntariness inquiry. And 321J18, contemplates the idea, I'm sorry, I seem out of time if I can continue. Contemplates the idea that implied consent, and Chapter 321J isn't exhaustive, isn't exclusive or mandatory, the be-all, end-all standard of admissibility of chemical test results, that there's going to be situations where you've got other competent evidence and you evaluate its admissibility by applying the law that would otherwise apply. When you've got a waiver of a privacy interest, you assess whether it's voluntary, the same way that we always do.
Statute in place that we presume that most people probably know about and kind of are operating under, and they're standing on the side of the road, and the officer says, will you consent to a test? And the officer says, I was just asking for actual consent. And then the defendant says, oh, well, I thought that I had all these other things, bad things were going to happen, even though the officer never mentioned 321J. So then the district court's going to be stuck having to decide in that context whether or not it was voluntary in light of the statutory scheme.
So I think that that would be a different case where you have a record that has some amount of testimony that the defendant was, in a sense, misled by the absence of information given. We don't have any of that evidence here. I don't think, and as always, when you assess a voluntariness claim, you're going to look at the effect you're going to look for government coercion, and you're going to look for the effect that it had on the willingness, voluntariness of the choice. So I doubt that kind of voluntariness challenge will often succeed at establishing that the person didn't, that the person's will was overborne, and that their consent was involuntarily given. But if it is involuntarily given, then it shouldn't be admissible. That underlying standard governs the admissibility of this evidence, because Chapter 321J, subsection 18, expressly disclaims the notion that it is the be-all, end-all of admissibility, mandatory and exclusive, which this court has recognized repeatedly.
Of this case, if I understand it correctly, in this county, the procedure was to request consent without invoking 321J. If the motorist denied consent, then they would go to a warrant. Is that right? So my concern is this: at least in some of our cases, we've indicated that because chemical testing is somewhat intrusive in terms of invading bodily integrity, that we want to give motorists a choice to give chemical test or not. And if they refuse, then we're going to honor that refusal. We're not going to give them kind of a false choice and then override it with a search warrant. And it seems like that's what this department's policy is you can consent because it's easier and more expedient for me to do that without reading you all the advisories. And even if you don't, I'm going to get a warrant, which seems inconsistent with the rationale of our cases about honoring a denial and not overriding that, because there is this balance between bodily integrity and the collection of evidence. So address that concern for me.
Understanding of Hitchens is that it's based on the statutory provision in 321J9 sub 1, that if a request to submit is made and the arrestee refuses to submit, no chemical test may be given. Now, that's not a constitutional rule. It only applies when you're in the implied consent framework. In theory, in Demaray, if he had refused to consent to releasing the sample, officers could have gotten a warrant and tested the sample that way. And I think the real intent there is to prevent the state.
The intrusion had already occurred. The statute doesn't say when the officer requests you waive your medical privilege. It says when you are requested to submit to a chemical test. And that had already been done in Demaray. The officer never asked for a blood test from that defendant.
Don't really draw the distinction between we don't really say that he lost the privacy interest entirely in the blood, as far as I understand, and that he did have to sign the release before the hospital could give the blood. So and Demaray doesn't get hung up on that distinction. Just to be clear. If that mattered, or if there were some sort of exigency requirement, or if that was a distinction that mattered, Demaray would have said so. It would have analyzed it. Maybe it would have remanded to the district court to make a showing of, see if there's necessity, like this court did in McGee. Demaray doesn't. Demaray finds it very easy to say, look, we're not in implied consent. Implied consent wasn't invoked. And so it doesn't apply. We apply the underlying law. I also I know I'm very over time. I've already cost you a lot of money, I think, so.
So you ain't done. Go ahead.
There's suggestions made that implied consent, we consider implied consent invoked when the officer has reasonable grounds to believe that the person was operating while intoxicated. And the idea is that when the officer has that reasonable grounds under this view, implied consent becomes mandatory and exclusive. This leads to the perverse result of defendants in motions to suppress arguing, trying to elevate the amount of proof that the officer had to believe that they were intoxicated, to then argue that now implied consent is mandatory and exclusive, and then they'll show the video and see, look where I swerved over the line. I don't think that makes any sense. And I think that officers, that's another reason why an officer might choose to go this way if they say, I am pretty confident in my reasonable suspicion, but I'm not confident that another reviewer would agree with me.
My next question, but I don't think so. I want a better answer than that. Pretend you are speaking at a county attorney CLE, and I raise my hand and I say, I'm a county attorney. Should I go home and tell all my law enforcement people, sheriffs and troopers and everybody in my area that they should start doing this? And if so, why? Why are they doing it? I can't get my head around that.
So you may, if you do this, do not under any circumstances mention any consequences of refusal, because that takes it into implied consent territory. It leaves the constitutional consent exception behind and goes into invoking implied consent by laying out the consequences.
Persuade me, what is the benefit of doing this?
The benefit of doing it is...
It was really difficult and telling me what I can. Okay, I got to first of all train him what not to do, but why?
So two benefits. One is if you have this person who's clearly agreeable and you don't see the benefit of reading the implied consent advisory, that they're already on board and they don't seem, a lighter touch will suffice.
That's being lazy. Because if I think I'm pretty darn sure that guy's drunk as a skunk, I want to ding him with DOT. I want to have all the beautiful things in the implied consent statute kick in. I don't want you to get a deferred judgment. There's so many, that begs my question. What benefit?
Maybe they're not drunk as a skunk, right? Maybe it's a situation where the officer thinks that this calls for a more amicable approach that doesn't bring the full power of the state to bear. The other instance in which this makes sense is if there's any doubt about the triggering conditions or the parameters of implied consent. Like I mentioned before, something intervening event has happened and now you're almost maybe 2 hours out from the triggering events. And so maybe if you do implied consent, it might end up tainting whatever answer you get if you can't remember the exact time when things started. Or if you have a potential, it's just good to have, there's a number of unforeseen situations where this could make sense. I also don't think that, if you're the county attorney asking me, should I do this or should I get a warrant? I mean, I always think it's easier to defend a warrant rather than any kind of consent. And this echoes something in Laub that this court said, warrants are generally constitutionally preferable. Why would we discourage officers from doing them? Well, from a constitutional standpoint, actual voluntary consent is preferable to implied consent, as you pointed out.
I'm gonna cost myself some money now. I mean, isn't one benefit that you haven't mentioned that and this is my concern, that it sort of allows the local law enforcement to cut the lawyer out of the situation? Because, and that's why I raised these questions about 80420, because in a normal situation, you're doing the implied consent. That takes time. There's a lot of mumbo jumbo. There's a telephone sitting there. The person is going to want to try and make a call and get some advice before they figure out what to do. And in this, kind of brief request for voluntary consent warrant situation, there's no lawyer.
Does that too, that the warrant kind of makes the advice of counsel irrelevant to a certain degree. Now, I'm definitely not saying 80420 doesn't apply. Same situation. If a request that could be within the triggering radius of 80420 is made, the officer should explain the right. Even if that request, whether that request comes during implied consent or if it comes in response to just this simple question, hey, will you take this breath test? So 80420 still applies. Now, I think that cutting the lawyer out of it, that may be correct in terms of the lawyer who reviews it later and goes through and looks for any potential, right? Because there's a lot of hooks in implied consent for people to claim like this particular part wasn't done right. And there's so much case law on it with these hyper-technical challenges. And I think that in some instances, officers may like pause and be like, something isn't right. There's, I'm not sure about the applicability of, I'm not sure which number offense this is. Maybe they have a conviction as a juvenile or from another jurisdiction, and I'm not sure whether that counts as a prior conviction, so I don't know which ones of these are applicable, and they're, right? So there are instances where an officer may think that it yes or no, simply, and we don't have to worry about any hyper-technical implied consent issues. And then if they say no, we can do what Laub says and get a warrant. And I don't think that if there is a concern that implicates, it's a concern that this court rejected in Laub, that this is no more forceful, this invades no more of a protected interest than this court allowed in Laub. It creates no consequences down the road that are different from what this court allowed in Laub. And so to allow officers to say, I wouldn't have them say, I'm going to get a warrant, because that undermines the voluntariness of the consent that you get. But just to say, will you consent to this breath test? And if they say yes, then they've waived the constitutional privacy interest that the warrant would permissibly override if sought and approved. I don't see any problem with that.
First, that your rebuttal time almost exceeded your original argument. Thank you. The case of State versus Flynn is hereby submitted, and the court is going to take a very brief recess before the case of State versus Berg. During that time, the attorneys can get situated for that case.